Hi, my name is John Skiba and I'm an attorney in the state of Arizona. If you're fighting a debt collection lawsuit, nothing can blow your case out of the water quite like a motion for summary judgment. You got served with the debt collection lawsuit, you've been searching on the internet, you're able to piece together an answer to avoid a default judgment. You may even muddle through the discovery process and your case is still alive and well. You still have that glimmer of hope that you may actually get out of this case alive. But then it happens. You get hit with a motion for summary judgment. Now, drafting an adequate response to a motion for summary judgment will separate the true consumer warriors from the rank amateurs. Your day in court has arrived, albeit sooner than you thought. If you don't put together a good response, or worse, if you don't respond at all, you may find your case coming to a screeching halt and judgment entered against you. In this video, I'm going to discuss 3 vital steps to defeating a motion for summary judgment. The first one is to get out your calendar. Now, if you follow any of my videos, this one should sound familiar because remember when you first got served with the complaint and summons, I told you the first thing you needed to do was pull out your calendar and mark when the answer was due. Same thing with responding to a motion for summary judgment. You need to make sure and mark your calendar with a deadline when it's due. Just like the complaint, if you don't respond, the court will assume you agree with everything that's been alleged and they're likely going to grant judgment against you. So how long do you have to submit your response? This is where you need to check with the local rules of civil procedure. But if your state modeled their rules after the federal rules of civil procedure, which most states did, you can look under Rule 56 and it will tell you. Under federal law and in most states, you're going to have 30 days, but make sure to check your local rules. Second thing you need to do is to see the big picture. An important part of responding to a motion for summary judgment is understanding exactly what the document is. A motion for summary judgment is the debt buyer's way of saying, look, Judge, the facts in this case are not in dispute. The only thing you need to do is give us a legal ruling as to who wins. Basically, the motion for summary judgment is a way to shorten the whole litigation process. Instead of a trial, the debt buyer is trying to win this case by filing this written motion. Third part, drafting your response. Now, this is the hard part. What do you actually need to write in your response? The key to defeating a motion for summary judgment is to show the court that there are still facts that are in dispute. Summary judgment is only appropriate if none of the facts are disputed. However, if there are facts that are disputed, the case should be heard at trial where each side can present their version of the facts and have a chance to cross-examine each other before the judge makes a decision. In the debt buyer lawsuits filed by companies like Midland Funding, LVNV, Portfolio Recovery, there are many facts that are in dispute. Here's an example of a few of them. First one is standing. The central fact in dispute in these types of cases is whether the plaintiff actually owns the debt that they're suing on. Typically, they have very little admissible evidence to show that they actually purchased the debt from the original creditor. Without admissible evidence showing that they purchased the debt, they don't have standing to sue on it. Sure, they may have provided other documents like affidavits and a few statements, but if you read these documents, they don't provide any real evidence that the debt was purchased. Generally, the debts are written by someone who works for Midland Funding or one of the other debt buyers. In these affidavits, they swear that they purchased the debt, but what else would you expect them to say? Of course they're going to say that. But where is their evidence? Where's the bill of sale? Where's the exhibit showing what specific accounts were purchased? They normally don't have those documents. So, the big fact at issue is that the plaintiff even has the right to sue you. You must present this in your written response to the motion for summary judgment. Another one that's in dispute often is the dollar amount that's owed. Even if the debt buyer could prove that they own the debt, and most I don't believe can, how did they calculate the amount that's owed? Did they just throw a 2-year-old credit card statement before the court and claim that that was the amount owed? How did they calculate the amount that they're seeking? What interest rate did they use? Did they properly account for any payments that were made on the account? They must show this. If they can't, then there's a factual dispute on how they came up with a number that should be dealt with at trial, not in a motion for summary judgment. Next thing you need to look at are facts specific to your case. Finally, if you need to bring up any facts specific to your case that may be in dispute. On more than one occasion, I've represented clients against debt buyers where my client had paid the underlying debt in full and had proof, canceled checks type proof, that the debt had been paid. If you've paid the underlying debt, or if you didn't incur the underlying debt, like with identity theft, then you need to make sure that these issues are raised as well. They are factual disputes that should stop the judge from granting the debt buyer's motion for summary judgment. One final note, after you draft your motion, make sure you file it with the court and then send a copy to the debt buyer's lawyer. The court usually doesn't do this for you, and if you don't send the other lawyer a copy, they'll never know you filed it. Again, draft a response that demonstrates there are still facts in dispute in your case and file it before the deadline with the court. If you can clearly demonstrate that there are factual issues that need to be resolved by the court, you should be successful in your battle against the debt buyers. If you have other questions on your debt collection lawsuit, head on over to my website at skibalaw.com, where I have other articles, videos, webinars, and even an audio podcast that deals with these specific issues and can help you in winning your case. Thanks for watching.